get started. So, ladies and gentlemen, thank you so much for joining us for this afternoon's discussion of the District Attorney's Office, and specifically the Los Angeles County District Attorney's Office. This discussion is a continuation of Loyola Law School's Zoominar program, where we feature distinguished guests discussing important issues of the day. And that is why it is my honor to welcome our guest today, Mr. George Gascon. He is here to discuss the issues that surround the Office of the District Attorney of Los Angeles County. Mr. Gascon will face off in November with the current Los Angeles County District Attorney, Ms. Jackie Lacey. Loyola Law School extended an invitation to Ms. Lacey, and to her campaign staff to engage in a similar discussion of the issues. To date, Loyola Law School has not received a reply to our invitation. That said, I'm going to give you a very brief introduction of Mr. Gascon, and then we will dive into a series of questions. So, George Gascon is a Cuban immigrant and an Army veteran who became a sergeant while serving our country. Mr. Gascon joined the Los Angeles Police Department as a patrol officer, and he eventually worked his way up to the rank of Assistant Chief of Police. From there, Mr. Gascon served stints as the chief of the Maricopa County Police Department, where he had to deal with former Sheriff Joe Arpaio and the San Francisco Police Department. Somehow, and I really want to ask him at some appropriate time how he managed to do this, he earned his law degree. And in 2009, Mr. Gascon was appointed the District Attorney of San Francisco. Mr. Gascon then subsequently won re-election to that office. Ladies and gentlemen, please join me in our warm welcome for our distinguished guest this afternoon, Mr. George Gascon.
Thank you, Professor Williams, and thank you, everyone. And just a quick minor correction. It was the Mesa Police Department in Maricopa County. The sheriff was the sheriff of Maricopa County, and I was appointed to District Attorney in 2011 when Kamala Harris became the Attorney General, and then I ran successfully twice. So I was a DA for for over 9 years.
Okay, thank you. That we should have the record straight. So the way we're going to start this discussion, I'm sure that many of our our listeners are familiar with the District Attorney's Office because it relates to our work and our study, etc. But that said, could you give us an overview of what a District Attorney's Office really does and what the District Attorney does?
Yes, and thank you for the question, Professor Williams, because I find that even in the legal profession, sometimes unless you're working criminal law or you have an intersection with the District Attorney's Office, often people don't realize the breadth and the scope of the work. I think that most people realize that district attorneys, are the recipients of the work from the police department, and they make a determination as to whether a case is going to move forward or not. And obviously that is incredibly important, because a district attorney can determine whether someone is going to be prosecuted or not, and to what level they're going to be prosecuted, whether they're going to seek incarceration or whether they're going to seek some other form of intervention, diversion, the length of incarceration, the severity of the charges that are going to be levied. Frankly, in many cases, and certainly in LA County, even the death penalty, which is something that I'm categorically opposed with. The current occupant of that office is a believer in the death penalty. So in addition to that work, there are many other pieces of work too. So the district attorney in California actually has the capacity to sue corporations and companies for consumer violations of consumer law. And they can do so criminally or civilly, which is a very powerful tool. They can go after environmental polluters. They have an obligation to investigate white-collar crimes, but also public corruption. They are the gatekeepers when it comes to police behavior to ensure that police is abiding by the constitutional requirements of the job. And they are supposed to review every police use of force that leads to the death of someone. The district attorney also has an outside influence in our political process. Often legislators, both at the city, county, and state level and nationally, often are looking for guidance from the district attorney as to what laws or what legislation to pursue. And quite frankly, if the district attorneys are generally opposed to legislation, it's unlikely that a legislation will pass because many of the legislators are very wary about being somehow categorized as soft in crime. And if you have your prosecutors against it, usually the next attack is that you're doing X, Y, and Z because you're soft in crime, which is it's a conversation that hopefully we get a little bit of time to move into. But the bottom line is that when it comes to criminal justice, the elected DA in the county is probably the most powerful position at county level. And LA County, being the largest county in the country, has an outside influence on what happens not only obviously in our county, but in the state and in the rest of the country. If you just take one simple look, there are approximately 740 people on death row in the state of California. A third of those come from LA County. That just shows you the import of the work that we do in this county, as well as the import of the elected district.
Thank you. One of the discussions going on now around the death of George Floyd, Breonna Taylor, and the like is the role of race in law enforcement. And some district attorneys' offices around the country now use race-blind charging decisions to reduce the impact of institutional racism. If elected, would you favor the implementation of a system of race-blind charging?
Yeah, actually, I believe that I was the first district attorney in the country who introduced artificial intelligence to mask race in all race proxies, so that when we made our initial charging decision, the filing team wouldn't know the race, not only of the person that was being reviewed, but the witnesses, the police officers, and all the other participants. And only after the charging district attorney made a charging decision would she or he be able to unmask the police reports and then see video and photos. And then the way that our system was set up so that it locked the first decision, so you cannot go back and change it. And then if you made a decision on your second go around, once you view the video and photos and all the other references, if you decided to go in a different direction that you originally did, when you had no awareness of the race or the parties involved, then it requires supervisory approval. And we did so because I thought it was really important to ensure that only for legitimate reasons could the original decision be shifted in a different direction. More importantly, what we did in San Francisco is we did several things, but two I think that were really important. Number one, we created this tool with the help of the computational lab out of Stanford University, and then we put her in the public domain. In other words, we offer it to every DA in the country at no charge, and we actually offer technical assistance to implement the program. But number two, we made a commitment at the inception of the development of the tool with Stanford that all the data that will be collected from the decision-making process will be made available to researchers, it will be available to policymakers, to legislative bodies, and it will be shared with the community. So I believe that we started a trend that is being taken by others, although I don't think I'm not aware of anyone just taking it up to the level that we have by the use of artificial intelligence. And if I were to be elected DA, that is a tool that I will be bringing over to LA County. And by the way, we offered the tool to the current DA. She never responded.
Thank you. And this question comes from colleagues of mine who are familiar with the DA's office here in Los Angeles. And they tell me that presently it is mostly senior prosecutors who make charging decisions. What is your position on the use of guidelines that expressly require all prosecutors to consider factors such as the impact on the defendant's family, impact on the defendant's community, and racial disparities in bringing a charge?
I think it's critically important. One of the things that I used to tell prosecutors in my office that we don't bring charges because we can. We bring charges because we should, because there's a greater good. There's a policy consideration that is part of that decision-making process. So one of the things, for instance, that we did in San Francisco that I would do here, we were the first one, and again, I think one, maybe the only one, that had sentencing planners. And the sentencing planners in San Francisco were social workers that looked at a lot of serious cases that we were facing, and they would actually work with the consent of the defense. They would interview the accused, and they would review the entirety of the case beyond the actual incident that was being charged, but sort of the underlying root causes of the problem, the upbringing, what are the family and network support systems, what the mental health issues and substance abuse, has it been a history of trauma, and then we would work to ensure that whatever solutions we were offering to the case would entertain all those factors that normally a prosecutor would never see. So while the original charging decision is made, very quickly, and quite frankly, you don't have the time to review all things, we made it a practice of actually dig deeply in the litigation process to make sure that whatever resolution we reach out to, it entertained factors that we felt that were very important, including the impact on our community, the family, as well as that of the victim. We always we worked on the presumption that most victims don't necessarily want retribution. Victims have been harmed. Often victims have been harmed many times. They have been traumatized. And unlike the typical depiction of the crime victim, often by the mainstream law enforcement groups, we know that the data shows that the majority of the victims in this country are people of color, they're poor people, they're people that have been traumatized over and over again. We used to have a saying in our office that actually started with the head of our victim services unit, which, by the way, used to be a lawyer, and I moved the lawyer out of that role and brought in a clinical psychologist with a PhD that has experience in trauma-informed care. And the sort of the blanket that we took is that hurt people hurt other people, and heal people heal other people. So we really work the process of trying to be healers and those that repair, as opposed to somebody that just simply seeks retribution.
Thank you. This is another question that comes from my colleagues who have knowledge about the current operation of the office. And they say that younger attorneys who come into the office with a commitment to social justice soon become acculturated to the good guys, bad guys perspective of the office. And reportedly, and I do want to underline that reportedly, young prosecutors who support reform then are marginalized. In other words, they're not promoted, or in other ways, they're basically made known that their view is not welcome. First question: are you aware of that perception with regard to the LA County DA's office?
Yeah, I'm aware of. Actually, I can tell you that I've had prosecutors in the office call me. I can tell you actually one incident that happened not too long ago, and I'm not going to say the courtroom because it would violate the confidentiality, but we had a young lawyer that encountered a report from a police officer that he knew from prior encounters that this officer had a history of lying. He believed that the officer was lying in this particular case, so the prosecutor refused to move forward with a report. The chief of police of the agency involved called the current DA, and there was a conversation with her in her number 2, and then this deputy was ordered to file charges. When he refused, he went on sick. They moved the case to another deputy who then went on to file the charges. So you have a culture that not only has created this us against them attitude on the good guy, bad guy, which is very, very damaging to the services that we provide, but we also created a culture in that office that looks the other way at clear violations of Brady, often people that have less than a truthful reputation, which builds into this attitude that it's a win at all costs, and that we're part of one team and everybody else is in the other team. I'm very aware of the problem. I can go on and on. I'm aware of sexual assaults in the office that, women that have been sexually harassed, women of color have been, the subject of racist behavior. Many of them have won lawsuits that unfortunately the county council will require a non-disclosure agreement, so you and I don't get the benefit of that, even though we're as taxpayers paying for that malfeasance within the office. So it's an office that has a very corrupted culture where good people are often marginalized.
So if elected, what steps might you take to change that culture?
Well, first of all, we would do the same thing that I've done wherever I worked before. Number one is that you elevate the people that have the values that you believe in. And in my case, the values of espousing principles of social justice and equality. Number two, you hold people accountable that do not hold those values and act upon them. Number three, you create very clear policies that create a line of demarcation as to what is acceptable, what is unacceptable behavior, and hold people accountable to those things. But more to the point, more specifically in the first 100 days, one of the things that I plan to do is actually have a management auditing firm come in and help us do a top to bottom audit of the working conditions in the office across the board, not only sort of people relationships and policies, but technology and many other things. And my goal is that will be the foundation, where we create a blueprint to start creating policy and rewards and a different way of doing this.
Thanks. And I should, yes. So obviously we're in a time where we've seen the tragic death of Americans such as George Floyd, Breonna Taylor, and the shooting in the back of Jacob Blake. District attorney is the public official who is most often tasked with holding law enforcement accountable, at least on the criminal side, for excessive use of force. What is your position on law enforcement accountability?
Look, I mean, the problem, one of the biggest problems that we have, and certainly in LA County is really kind of the poster child for this, is the conflict of interest that often exists between elected prosecutors and police. The elected prosecutor is supposed to be an independent gatekeeper of the entire system. That means that you support good police work, but you also hold police officers accountable when they violate somebody's constitutional rights and when they break the law, whether it's through excessive use of force or lying in court. In this case here, we have a problem because we have a DA that is heavily conflicted because of her relationships with the police, the high sums of money that she's taken from police unions, the endorsements. So again, we have a culture that has taken us to a place that needs to be completely revamped. When I was a district attorney in San Francisco, I bumped into many problems with police. I was the only district attorney in the state that supported reforming the law around police officer use of force to provide greater accountability for police when they use deadly force. The current DA refused to join me. In fact, no other DA did, but this one specifically refused to do so. And we have seen over and over again her refusal to prosecute cases where you have even unarmed people. We've had 12 cases at least that I'm aware of where you had unarmed individuals that police has used deadly force. In one case, even having a chief of police asking for a prosecution and her finding a way not to do so. So we have a lot of work to do. As a candidate right now, I have a group of civil rights attorneys that are working with me to evaluate past uses of force. I have committed that I would create special prosecutors to look at some of these cases where the group feels that our cases are worthy of a second look. And more importantly, I've committed to actually seeking legislation, much like I did on the use of force side, seeking legislation that eventually will provide the county an avenue to take the work of reviewing police use of deadly force, any allegations of criminal conduct while on duty, and be given to a separate entity outside the DA's office that would have full investigative and prosecutorial authority.
What steps would you take to address some of these issues? We've had several incidents, I can't think of names right now, but recent police shootings by the Sheriff's Department, Los Angeles Police Department. How would you, and what in terms of your experience being also a former police chief, what steps would you take to address the question of how you police excessive use of force?
Yeah, so a couple of things. As it's in the process right now of building up during the election, and what I would do if I were to be elected is working with a group of civil rights lawyers that specialize in the arena of police use of force. And we're beginning to review cases where the current district attorney has said that the shooting or the use of force, the use of deadly force is okay, and where there are differences of opinion. And the goal of reviewing this case is to assess if any case should be prosecuted, and if so, as I mentioned earlier, I would be appointing a special prosecutor outside of the office to do that work. And the reason for that, frankly, is twofold. Number one, I'm going to be walking into a new office where there's a lot of hostility to reform, and I want to make sure that while we're working in the culture, we don't compromise the potential prosecution of the case. And number two, I believe that the public really has come to the place where they do not believe that a local prosecutor can do this work unbiasedly and transparently. So in order to sort of eliminate that concern, I want to create that special prosecuting role, which would be somebody that has experience in the work, but is outside of the office. The second thing that I will do, as I did in San Francisco, is look for, begin to beef up our own capacity to investigate police departments and any allegations or the perception of corruption, especially that on duty, and utilize the appropriate legal tools that we have to investigate these cases, including the use of grand juries where it's appropriate, but we're not getting to the bottom of things. And, there's a lot of concerns about behavior, but it's unclear what actually happened. Finally, I believe that it's really important for the local prosecutor to partner with the U.S. Attorney's Office in these cases, and I did that in San Francisco, and we'll hopefully do the same thing in L.A. We have different tools, much like the California Attorney General. I believe there has to be a system approach to police corruption and police abuse of their authority. And while the district attorney certainly holds the major role, I think it's important to bring other partners to the table as well.
Thank you. I'm going to say real briefly, I'm seeing some questions in the Q&A, and I wanted to make it clear to our audience that the documentation you're seeing is something that we arranged when Mr. Gascon agreed to participate. And we would do likewise for District Attorney Jackie Lacey if she accepts our invitation. And it's very difficult otherwise for us to answer those specific questions I'm seeing. Turning back to another issue that's very important here, the use of perjured testimony and dubious evidence created by law enforcement has often been a basis for vacating criminal convictions. Our school has an innocence project and has freed a number of people where part of the basis of the conviction was either perjured testimony or falsified evidence. If you became aware of an officer who has perjured herself or himself or created dubious evidence, how would you instruct your prosecutor to deal with that case?
Well, to begin with, in San Francisco, we established a policy. We had a no-call list, and we have both an internal and external. The internal was in cases where we became aware of officers that had a history of lying. We made it very clear to the police department that we would not use them as material witnesses. In cases that were presented, but depending on their testimony, we did not move forward. We also had a policy that actually the California Supreme Court in dicta during actually an LA County Sheriff case cited as the model policy for the state. And that was a policy that we required the police department to release any information that they had concerning any Brady violations. And then if those were we provided the defense with the fact that there were information that they needed to explore further, and then it would go into an in-camera hearing with the police department, and the judge would have to make a final determination whether that information was made available or not. But the bottom line is that, number one, you have to make sure that as you're litigating a case, that your case is as pure as it can be, and that you are, you're sort of gatekeeping to make sure that we're playing by the rules, and certainly that we're following our constitutional requirements. Post the conviction part of it, when you become aware, when cases are being brought to your attention where the conviction was obtained either wrongfully or through through perhaps violations of discovery, I think it's really important not to have a very quick, thorough but quick approach to the work. And when you determine that you were wrong, that you admit to it, and that you don't necessarily push people into litigating to try to show something that obviously occurred. I think that the current conviction review unit in the EA's office, I personally believe, is a disgrace, frankly. I don't think they're really a conviction review. What they try to do is they try to reinforce and try to affirm bad work, and they make people go through a great deal of pain and suffering in order to be able to prove their cases. If I were to be elected, my goal is actually to create a true conviction review unit that when we determine that we were wrong, that we don't force people to litigate, but we just simply move on and cure the damage and the harm that was done. But obviously, I believe it's more important to try to avoid the damage in the first place. So certainly in the litigation process, we need to create strong bumper guards, if you will, to make sure that when we have questionable information, that we don't move forward on that information.
Your answer may have covered this, but I'm going to ask anyway. What, if anything, can a district attorney's office do about officers when they find out either that they have lied in cases or created evidence that is tainted?
Well, I think, first of all, even it's starting at the very top. If you believe that an officer committed perjury, and now I'm talking about legal perjury, right? There was a violation of the law. I think that the district attorney has an obligation to prosecute that case. And I think that will establish a very clear guideline that we hold ourselves to a very high standard. I think that when you have, evidence that people have perjured themselves or have a history of providing misleading or false statements in their reports or investigation, but that where it doesn't rise to the level of a prosecutable offense, you still need to make sure that people like that are not being called to provide testimony. So what you do is you do what we did in San Francisco. We basically created a policy that officers that had a history of lying or providing misleading information, police reports, arrest reports, they would not be called as witnesses. And that puts the law enforcement agency on notice that they either have to shift their practices or they have to figure out a way not to use those officers anymore.
Thank you. Another thing along this line, and this I've heard myself, defense attorneys often complain that prosecutors fail to disclose exculpatory evidence despite their ethical and constitutional duties to do so. How would you address that problem?
Well, I would address it the same way that I have in the past. I think that if we determine that a prosecutor has withheld exculpatory information, an investigation needs to be conducted, and if in fact exculpatory information was withheld, depending on the reason for it was intentional. I think in my book that's grounds for termination, so that we discipline on termination. If we find that it was through negligence or some other systemic problem, then those will be addressed through training or other means of system fixes. But I think regardless, it's imperative that as prosecutors, that when we become aware of deputy district attorneys or anybody in the system failing to provide exculpatory information, that be immediately looked upon. And it has to be you have to establish a culture that has zero tolerance for this behavior. When I became the district attorney, and I was a DA for almost 9 years, one of the things that I used to do as part of our training was, and we show that regularly, there was an Innocence Project video that showed wrongful convictions. And we use that as a tool to have conversations around the impact of the obligation of the prosecutor to be, fully transparent and to discover the things that they are required by law. Frankly, I'm a strong advocate for open discovery. We obviously have some legal requirements that we have to make sure that we guard against, but I believe that when you create an open discovery policy, you create a better culture both for the defense and the prosecution on this issue.
Thank you. One more related question in this area. California Rule of Professional Responsibility 3.8 now requires that prosecutors timely disclose to defense counsel all evidence that tends to negate, I'm kind of quoting from the rule here, all evidence that tends to negate the guilt of the accused. And the rule also requires prosecutors to promptly inform courts and defense counsel of credible evidence that a convicted defendant, in fact, did not commit an offense. The question is this: when Rule 3.8 was proposed during the California State Bar's drafting process, my colleagues tell me that the LA County District Attorney's Office opposed that rule. And I'm curious as to your reaction about that.
Well, I think it's consistent with the culture of the office today, right? The office is an office that has a well-earned reputation for not playing by the rules, from hiding exculpatory information. And I think that it's just simply consistent because what we're trying to do is make sure that they are not held to a standard that requires this even on a higher level that already is, by the way. And I don't know how you could make it any higher, given that, Brady versus Maryland occurred in the mid-1960s, so it's not like it's new law. But it's concerning on many levels, but I think it's also consistent with what I've heard and what I've seen. And that's why, I'm going in with why I understand that there's going to be a challenge dealing with a culture that at the top has encouraged really bad behavior that unfortunately it permeates through the line deputies. And as you mentioned at the very beginning, we have a lot of good lawyers that go in with very idealistic intentions of being, sort of social justice warriors within the district attorney's office, and they often get squashed. So we have to shift that culture, and we have to elevate people that think that those are important characteristics for a prosecutor to have.
Let me pose to you a couple of questions we've gotten from the audience. One, how would your office, if you were elected, how would your office work with groups like Innocence Projects? What would be your instruction to your staff in that regard?
Well, to be honest, I've had already some conversations with the people on the Innocence Project because I believe that in order to create the what I hope will be the national model for conviction review, I'm very hopeful that the Innocence Project will be a partner in this process and help me create and engineer that type of work. So actually, my goal would be, if I were to be elected, is actually, Loyola, as well as other partners in the legal profession that have worked on the conviction reviews and Innocence Project will come in and help us restructure that unit. Much like, by the way, I'm looking to people in the environmental world to help us, sort of rejuvenate, if you will, our environmental process or police accountability. If I were to be elected, I am very determined to bring in community voices, especially those that have been harmed by it, as well as those that are experts in the various areas, to get their input and their support in order to bring our practice to what I consider, what should be the model for the nation. And certainly when it comes to conviction review, I would welcome the participation of many of the people that work in the Innocence Project in Loyola today.
Another important question from the audience. In the Los Angeles District, and I'm quoting, the Los Angeles District Attorney's Office has a rigorous ethics policy. We already have all of the safeguards that you say you will implement. How would you respond to that question or that statement?
Yeah, I think it's wonderful to have written policies. I think that the problem that culture has to follow policy, and deeds have to follow policy. And what we see repeatedly coming out of the LA District Attorney's Office is not anything that I would be proud of. And I hope that those that are listening to this, especially those that work in the office, do not take this as a personal assault. This is not intended to be an individual personal assault. This is an assault on the system and on the leadership. You may have wonderful policies written. In fact, I can tell you, most police departments have wonderful policies written about, the role of policing to protect and to serve and all that. But at the end of the day, it's when the rubber meets the road. And when the rubber meets the road in our legal system, we have seen over and over again the actions of the LA District Attorney to be contrary to those policies. So my goal is not just to have written policies. My goal is to make sure that those become living documents that we all live by, starting from me and going to the youngest member of our legal practice.
So I'm going to ask you one more question and then turn to a couple of other things we looked at in advance. Have you personally prosecuted criminal cases in court?
Yeah, I have not. My history was one of policing, and I worked the civil work before that. So I've never actually personally prosecuted a case. I did some appearances when I was a DA, but I have led prosecutors for about 9 years and created an office that many looked upon as the model office in terms of professional responsibility. And what I tell people is often when you jump on an airliner, you probably don't know this, but most of the people who run airlines have never flown a commercial airline, right? But your concern is the plane going to be safe? Is the plane going to take you to the places that you hope to get there and that you're going to get there in a way that you feel that you will service appropriately? And I think it's the same thing here, right? We're not hiring a trial lawyer. If we were hiring a trial lawyer, then obviously you either are hiring an entry-level lawyer that has no experience, or you're hiring somebody with experience, and you respect that. If you're hiring an executive that understands the legal system and knows how to run large organizations, and that's why I feel extremely confident, because when you compare my history as an executive running a DA's office against the current one, you see the very stark difference. I was not plagued by the number of internal problems, including sexual harassment, including discrimination, including wrongful convictions to the level that we have. There's just so much wrong with the office today, and that's directly reflected on an executive that has not been a good leader.
I appreciate your frank response on the direct question about trying cases in court. I'm going to shift gears for a moment, and this question is going to take me a little bit of time to set up, so please bear with me. In particular, and this is certainly not unique, but the African American and Latino communities in Los Angeles have suffered and continue to suffer deep-rooted traumas created by historical patterns of violence. The LADA's office has traditionally treated episodes of violence, as criminal or non-criminal, and if criminal, as matters for prosecution and punishment. Yet many instances of serious violence within families, within neighborhoods, and within communities occur, and sometimes the insistence that people involved in those conflicts be treated as bad guys in particular can do great damage to families or communities. So the first question, do you see the district attorney's office, and this is a criminal justice reform movement that's out there, having a role in community-based restorative justice initiatives?
Not only do I see it, but as a DA in San Francisco, I started several full restorative justice models. Number one, we started a concept that now has taken hold in other communities called neighborhood courts, where we actually diverted cases away from the criminal justice system to resident consuls that were trained by a nonprofit to do sort of mediation and adjudication of many low-level offenses. When it came to children or those under 18, we established the use of the museum community conferencing model. We work with a nonprofit to divert serious cases. In the case of juveniles, misdemeanors, they were all diverted to a nonprofit, so we are only dealing with serious offenses. And we found that the fully restorative justice model actually yield much better results than the traditional criminal system. And the reason why we know this, we work with researchers, and for the first 3 years, we had a control group, and we found out after about 3 years that the kids that went through the restorative justice model performed much better. We also started the first in the country young adult court, which for those 18 to 25. And that was while I was in the courtroom with the judge, and you had a public defender and a prosecutor. We brought in nonprofits to help us with the interventions and found that to be extremely helpful. And then finally, I created a series of community advisory groups, including one of formerly incarcerated returning men and women from our prison system that were incredibly helpful in the shaping of our policy. I think is absolutely essential that we bring the community to many of the solutions that are often the best solutions to a problem are not going to be the ones that the police and the prosecutors can provide, but sometimes they need to be community-based. Or quite frankly, if you're dealing with mental health or substance abuse, that you bring experts in those fields to deal with those issues as opposed to us.
Okay, another question from our audience. And this is two parts. Let me do both parts before you respond, please. The basic question, if elected, do you have a plan for putting more effort into recruiting deputy district attorneys who are people of color? And now, attached to that, the questioner, I am an evening student and a victim services representative for the Los Angeles District Attorney's Office. I have seen how navigating the criminal justice system re-traumatizes victims, especially those from the immigrant and Spanish-speaking communities. A very small percentage of the deputy district attorneys speak Spanish, yet a large portion of the population, particularly of victims, that we serve is Spanish speaking. So that gets to the question, if elected, what would you do about recruiting more district attorneys, both who are people of color and those who are bilingual and able to service those victims for whom English is not the primary language?
Yeah, so let me begin by saying that to me, diversity is more than just simply the color of your skin. It's also diversity of thought. So it's important to make sure that as we're recruiting people of color, that also think differently than many of us do in the criminal justice system. But let me also tell you what I did and what I plan to do. In San Francisco, we were very intentional about a diverse workforce. In fact, we became a majority minority and a majority women office, including my direct staff. 2/3 of my direct reports were women of color. When Stanford Law School did an analysis of representation in its 58 county DA's offices around the state, they concluded that San Francisco had by far the most diverse DA's office in the state of the large offices. And I tell people that doesn't happen by accident. That was intentional. We put a lot of effort behind that. We also put a lot of effort behind our linguistic capacity. If I were to be elected district attorney in LA, I would follow the same path to ensure that we are recruiting a diverse workforce that represents the people that we serve. And not only that it does so in their color of the skin, but there's also cultural and linguistic sensitivity. It is extremely important for us that, in addition actually to speaking other languages, that we also understand cultures. So the answer to that is that I have been one that has been recognized for this work before. And if I were to be elected, I would definitely be following on that path because I think it's critically important in order for us to maximize our capacity to serve.
Thanks. If elected, would you be in favor of having an outside person or entity to whom deputy district attorneys who are troubled by practices of the office, their superiors, or police officers can report those concerns?
Absolutely. I think it's critically important for organizations, especially for governmental organizations, to be open to the public and have outside review of their work. And for all the areas where the law permits, I think it would be a welcome opportunity to have that capacity for employees to be able to go outside of the office and seek redress, especially in those cases where they feel that if they were to report internally, they may be the subject of retaliation. Now, hopefully, we will get to a place, unlike I know what is currently happening, where people will come openly because there will not be any fear of retaliation. In San Francisco, we got to that place by and large, and I would hope that we will do the same thing here.
So this one also, based on the experience of some of my colleagues, former district attorney for Los Angeles, Steve Cooley, had outside lawyers who would come in periodically to look over the systems and resources of the LA office, some of the procedures, and that process seemed to be helpful in creating change. Would you consider restoring that practice?
Well, I think actually I would go one step further. I don't think it's enough just occasionally on an ad hoc basis, bring in outside people, especially people that are your friends, to tell you what you want to hear. I think it's important to have a regularized process of outside review of our work. And this is quite frankly where I welcome, for instance, people from the Innocence Project working with us in the development and the operations of our conviction review, just as I will welcome other partners. But I think it has to be more than the ad hoc way of doing this. I think it has to be a regularized opening of the doors and having ourselves open for other people to look at our work.
One of the things that's happened recently around the movement for reform in the criminal justice system is a desire on the part of the public to have more direct interaction, if you will, between those who are in charge of the arms of law enforcement, both the police department and the public defender's office. The question, would you favor having a process for regular interaction between, if elected, between you as the district attorney and members of the community?
Yeah, again, I think I mentioned earlier that I had a series of community forums where people from a variety of backgrounds were invited to come in, and they in turn could invite other people. So it's not just my own invitation, but it was invitation sometimes of other members. My goal actually is to do something similarly here, with one added distinction in San Francisco, because we were much more denser populated and neighborhoods were very closely one to the other. We did not have the geographic differences to the extent that we have in LA County. Not to say that there were not differences, clearly they are, and there's starking difference when it comes to economics. But LA County is so vast that what I've heard, especially during the primary election before COVID, where I was traveling the county regularly, was the almost feeling of disenfranchisement by people in places like the Antelope Valley or Pomona or other parts of the county, the southeast area of the county, which is where I grew up, where they feel that they're often ignored by the DA's office and county government. So my goal would be to create structures around regular consultation and regular discussions about the work. The other thing that I did in San Francisco that I would hope to be able to implement in LA is we created a program of neighborhood prosecutors. And neighborhood prosecutors were lawyers, actually would rotate out of the trial assignments and work for a period of time in communities, becoming a conduit for information from the community back to the trial teams and to the office, as well as communication from the office to those. So it's really a twofold process. One is at ground level, establishing lines of communication. The other one's at the top, myself and my immediate staff, having a very regularized interaction with the people that we serve across the board.
So you personally would participate in these things on a periodic basis, with
Yeah,
open to the community.
yeah. The advisory forums that I did, I was always pressing on the regular meetings.
Thank you. This is a question that comes from a former prosecutor, actually. Should the district attorney's office continue to use a 3 strikes provision to enhance punishment for strikes that were imposed when a defendant was a juvenile? Related to that, in juvenile proceedings, the defendants, or what, I'm sorry, I know that's not the proper term, but I'm not a criminal lawyer. Juvenile defendants don't have a full set of constitutional rights. What's your position on using strikes that were imposed while a defendant was a juvenile?
Yeah, so first of all, let me just tell you that if I were to be elected district attorney, we will work, as I did in San Francisco, to endeavor not to strike juveniles. I know sometimes the law is very restrictive in this area. So the first thing I would say is try to avoid striking juveniles when we can. The second part of it, to the point that you made, I will give you actually a broader answer. And my answer is that I have pledged already to reduce or almost eliminate the use of 3 strike prosecutions in general. I don't believe that status enhancements necessarily make our community any safer. In fact, I believe all it does is drive the terms of incarceration to levels that are both socially and economically broken. I have my own evolution in this area. And in San Francisco, we came to the point that any sentence over 20 years require executive approval. And we pretty much stopped using gang enhancements and other enhancements that we're using at the beginning of my term. I have pledged not to use those. And my goal, if I were to be elected, is actually lower that threshold to around 15 years. And the basis for this, by the way, is not just an electoral conversation. Is I've studied other legal systems as well as the science, and there's a lot of science that tells us today that the length of incarceration is not necessarily impactful of safety, but what it does do is often guarantee more insecurity and quite frankly, more social breakdown. So we need to really rethink in this country the length of sentencing, and I certainly would do so if I were elected DA.
Another question from the audience, it's one I know that judges are also wrestling with. If you were elected, what would you do in terms of protecting your attorneys, victims, and witnesses in terms of having trials while this pandemic is still in force?
You know, frankly, I think it's almost immoral the way this office has proceeded during the pandemic. And I was the first one to come out in early March, actually, and challenge the office and the system to begin to start looking for ways to releasing people and reducing trial work during this horrendous time. There are many cases that were being filed that really needed not to be filed immediately. They have plenty of time to either resolve the cases or wait until we have more clarity. If I were to be elected, I would be working aggressively with the public defender, the defense bar, as well as the bench, to make sure that, number one, we reduce the need to have in-person appearances of any kind. Number two, that we, where we can, that we resolve cases without having the need to actually have jury trials. I think that we're putting a lot of people at risk, not only our lawyers, but we're putting at risk witnesses, survivors, and the community, especially when we're dragging in people into jury duty in conditions that are very unsafe. I have personally seen the conditions on the Hall of Justice and the elevators. So we really need to be thoughtful about this. I have to say that, the public defender already suffered a loss as a result of this, LA County Public Defender. And I want to make sure that I do everything that I can with the other stakeholders to make sure that that does not reoccur in our county.
Now, this question is a general one, and I do not. I want to underline that, and the people who helped me form these questions say that this is a practice of the Los Angeles County District Attorney's Office, but there are instances that I'm personally aware of where prosecutors have used blanket affidavits of bias in criminal cases to effectively remove judges from the criminal bench. What is your position on that kind of practice?
I think it has to stop. I think that when we're going to when we're going to remove a judge from a particular case, first of all, that has to be approved at the very highest level of the organization, and that has to be done only in cases where there's evidence of inappropriate bias by that judicial officer, not because a judicial officer may disagree with our filing decisions or our posture. Judges are elected by the people who are appointed to be the fair and unbiased arbiters of the law. They're not there to be our friends or to agree with us. And simply because they are not favorable to us is not a reason not to have them in a case, and that practice will stop. Again, it would have to be very clear that there are inappropriate biases that have been reflected on the prior work or other evidence of that before I would ever approve removing a judicial officer from a case.
On the issue of bias, and this is turning 180 degrees, and again, this is based on discussions with people experienced, some public defenders, some criminal defense attorneys in private practice say that there is a problem of both unconscious and conscious bias with some of the experts that are used in trials, and that problem is especially acute for defendants who are African American or Latino. Let's do it this way, assuming that is a problem, what would you do about that?
Well, I would say that I agree with those that pose the question. I believe it is a problem, so I'm going from the basis that I am not just simply wanting an assumption. I believe that I've seen evidence of that. I think, much like a lot of the other work that is going to be needed to be done in the office, where I'm going to need a lot of outside help, is in revamping our policies and practices and procedures to ensure that we have a screening process for the expert witnesses that we use, to make sure that we're using people that do not have those characteristics, or certainly that haven't shown those characteristics in their prior work. So creating those filters is going to be important, and frankly, it's going to be very important for me to get the help of others, because as you can tell, it's not going to be easy running an office of about 2,200 people in a county of 10.5 million people, and single-handedly turning a culture that has been created by many years, turn it around that quickly. So it's going to require assistance from others and participation. I tell people that if I get elected, that's only the beginning of the work.
Thanks. Let's see. What is your view, to the extent that you have knowledge about the habeas unit in well, actually, let me rephrase the question. What was your practice? Did you have a habeas unit in your office in San Francisco, and how did you have that unit approach petitions for a writ of habeas corpus?
Yeah, so what we did is and this took it took us almost 5 years to put it together, but we created an independent investigation bureau. And the charge of the independent investigation bureau was really primarily twofold. Number one was to investigate police shootings and allegations of police criminal behavior on duty. And the other one was a conviction review unit. And we hired lawyers with civil rights experience. In fact, we brought in lawyers from the former U.S. Justice Department under the President Obama administration to join us. And we brought in also a prosecutor with experience in war crimes prosecution in The Hague. And the goal for this unit was to begin, after we clear out the backlog of police shootings, was to begin to open up the review of cases. It never came to full fruition while I was there, but the work started, and it's my understanding that now is being continued to build upon. In LA, I see a very different scenario because I see a scenario, number one, of a large number of at least alleged wrongful convictions. That was not the case. We have some in San Francisco, but nothing even proportionally. And I understand the numbers are different, but just proportionally, the numbers are LA is just so high. And there's a unit there, but unfortunately, the unit appears to be extremely ineffective, or certainly not structured to do what the title of the unit entails. So my goal is going to be to, again, review the work of that unit, and then begin to re-engineer how we do that work to make sure that we do it appropriately.
Another question from the audience that goes back to the experts question. And I'm quoting, the experts come from a court-appointed list. Two things. If that, let's accept that, what would you do about the problem of bias if in fact this is a result of people who come from a court-appointed list?
Well, I mean, look, this is where collaboration comes in. If you have people, first of all, much like you should never put a police officer in the stand that you know is a liar, you should never bring an appointed witness that comes from a court-appointed list. Just because they're on the court-appointed list doesn't mean that, that they were ordained and that you have no other options, right? If there are not enough people in the court-appointed list, then you have to get together with the presiding judge and the public defender and other stakeholders and begin to recruit people for that list that will be reflective of the needs of our community. But I think, well, not that I think, I would refuse to put a witness that I knowingly have information that they bear racial biases or other inappropriate biases that will influence their impact in the litigation. I mean, that's unlawful. Obviously, it's a violation of our canons of ethics. So just because they're on an appointed court list doesn't mean that we have to go along with it, much like we don't have to go along and prosecute a case based on the testimony of a cop that has been lying.
Okay, let me see. If you were elected, would you support the district attorney's office engaging in collaborative training of new prosecutors with the public defender's office and/or community organizations?
Yes, absolutely. I was the first elected DA in San Francisco to be invited to go to sessions in the public defender's office, and we made that available to the public defender. And then our training units, although we never had both, I don't recall having both public defenders and DAs in the same room, but our training members or our training staff in the DA's office and the ones in the public defender's office often collaborated in creating, in dealing with, new procedures and new things that were coming together, where there would be a sort of a alignment of the way that we did the work. I don't think we went far enough. So certainly I will be open to a broader participation in this process. As to bring in outside community members, we did that regularly, and I absolutely would be wanting to do that, as well as the more than community members. There's also experts from other fields that can come in and help us understand or do our work in a better way.
A related question. Would you support giving new prosecutors more freedom to make plea bargaining and charging decisions on their own?
Yeah, and I think, look, I mean, this is an area that I don't hear all the time about, especially young prosecutors being, completely tie their hands as to what decisions they can make. And I think part of this is, creating obviously a culture within the office that trains people into the values and the understanding of the law. So, when you're working, when you're offering a deal of when you're filing a case or you're prosecuting a case, I think your decision should be informed by two basic tenets. One is a good understanding of the law, which obviously entails knowing your evidence and what the case is worth. But the other is a good moral compass about, what should we be doing as prosecutors. And it's going to be really incumbent upon me and those that I put in leadership to make sure that we begin to create a culture and that we equip people with a capacity to do the work accordingly. And as we're doing so, I think that greater freedom can be given to people to make their own decisions. But I don't want to lead anyone to believe that I would just simply take a hands off and let, individuals do their own thing in the courtroom, because that precisely is some of the problems that we have today. For that matter, we would have some people in the office that would be seeking the death penalty, even though I'm against it. So obviously, there are things that are going to be off the table. So it has to be a balance. But I think that, with the increase in training and the shaping of the culture, obviously, I want to give people a lot of latitude to be able then to work accordingly, because they should know their cases better than anyone else.
Couple more questions. When you were the San Francisco District Attorney, did you participate in the California District Attorneys Association?
I did for the first 6 years or so. And then I increasingly became, although I never cut off my membership, I increasingly became more disengaged. I found that my values and those that the organization espousing were contrary. I found myself, quite frankly, often lobbying in Sacramento and making appearances at committee hearings where I often had the California District Attorneys Association being on the opposite end. And that wasn't just once, but that was consistently. Much like I found the lobby for the LA County District Attorney, also on the other side, it got to the point that almost any criminal justice reform that I engaged in, or others, and that I supported, were always opposed by the California District Attorneys Association, as well as the current District Attorney in LA. So I increasingly disengaged from that organization. And if I were to be elected, I don't know that I will be an active participant in it anymore.
Well, let me look at our audience questions once more. Okay, here's an important question, and this is a little long, so let me run through it. In 2016, and this is from our audience, so I'm quoting, a study found that almost 1 million people on the sex offender, of the 1 million people on the sex offender registry, about 2/3 of them were Black men. In 2018, the appeal reported that 1 out of 100 Black males were on the registry. And so the question is, what is your position on the use of the sex offender registry? And in your opinion, does this indicate a disproportionate impact on the African American community?
Look, I think the registry shares the same problem that we see across the system, right? The systemic racism that has plagued the criminal justice system, whether you're talking about the registry or you're talking about the enforcement of drug laws or you're talking about police enforcement or the length of sentences or the use of the death penalty. I mean, you pick your poison and you find that systemic racism has permeated almost every part of our work for years. And I think it's important that as prosecutors, we begin to have earnest conversations about what the system has to look like in order to turn that around and to get into another direction. I don't know what the statistical numbers are for the white population, so I'm not sure if 1 in 100 is too much or is comparable. But without knowing the comparison, I just simply can tell you, is based on my own personal knowledge, just in very general terms in the system, is that we we are plagued by systemic racism in the criminal justice system, and that has to be addressed. And there are going to be many different solutions to that, and some are going to be immediate, others require more work. But if we find, in assuming that it is a case that, that the 1 in 100 when compared to other groups is disproportionate, and it shows that there is an inherent bias in the registry system, which I suspect there probably is, then, I would need to educate myself in that area and figure out ways to ensure that we are not participants in that broken system.
All right. Thank you, Mr. Gascon. Ladies and gentlemen, thank you so much for sitting in on this session. I will emphasize once again, there is an outstanding invitation from Loyola Law School to District Attorney Jackie Lacey to participate in a similar discussion with similar questions. But I do want to say, Mr. Gascon, I really appreciate your participation this afternoon and your willingness to engage in questions. And I also want to thank our audience for a number of questions. Sorry that we could not get to all of them. And ladies and gentlemen, that will conclude our session for this afternoon. Again, Mr. Gascon, thank you very, very much for a very informative afternoon.
My pleasure, Professor Williams. Thank you. I look forward to staying connected.
All right. Bye-bye.